counsel also discussed United States v. Coughlin and said that the flashlight was fine. However, the defense does not dispute that point.
30 seconds.
What matters in this case is that the officer trespassed on my client's private property. It doesn't matter if the tire goes on the road or on something dirty. That's not the test for plain view. For plain view, it's whether the officer has a lawful right of access to that place. And because it is my client's private property and it constitutes as a trespass, the officer was not lawfully present. Therefore, under the CATS test, my client had a subjective and reasonable expectation of privacy, and therefore I ask that you grant the motion.
Thank you. You got a vote?
As the defense mentioned in their rebuttal, nowhere does it say that he actually touched the hood of the car. Rather, he hoisted himself over, but not touched the hood of the car. He rather leaned over the hood of the car to get a better vantage point of the items which were in plain view. The defense further cites CATS v. United States to point out the two-point inquiry that determines if a person has a reasonable expectation of privacy. The defendant did not meet these two expectations. She did not intend for her belongings to be private, as her diminished expectation of privacy led to this. And two, society did not view the intention of privacy to be reasonable. If the defendant truly wanted her items to be seen, then she would have made sure she did show it instead of letting them be seen in the back of the car.
Say that again. I didn't hear. Go ahead. Say it again.
Society did not view her intention of privacy to be reasonable. If the defendant truly wanted their possessions to be hidden, then she would have made sure she did so instead of letting them be seen in the back of the car, such as hiding it in a glove box under a seat. Nobody would have been able to see them that way, and this would have been a problem. Furthermore, the defense makes the complaint that Officer Doherty had no warrant and not legally present next to the defendant's car. But in Texas v. Brown, it was ruled that the use of a warrant is a needless inconvenience, and the police have obtained first-hand perception of incriminating evidence. This first-hand incriminating evidence came in the form of weeks earlier, where Concha asked Officer Doherty if he wanted to hook up with Addie, this later referred to as Adderall. This first-hand it came in the drugs. This also first-hand incriminating evidence came in the form of drugs in the back of the defendant's car. This suspicious roll of pills was alleged in the back of the car. The prosecution requests that you deny the defense's motions based on these grounds. Thank you.
Anything further?
Your Honor, the defense is not allowed to make another statement.
Thanks. All right. Please give the court a few moments. We have scores. Give the scores. Are you scoring pre-trial motion? The court has listened and considered the arguments of both counsel and holds that the motion to suppress the evidence that the officer saw through the front windshield of the SUV is granted. The court finds that in stepping on the wheelbase or the wheel of the SUV, the officer violated the defendant's reasonable expectation of privacy. That's the court's motion. Thank you very much for your efforts.
Yes, Your Honor. The defense asks permission to rearrange.
In the matter of People versus Concha, is the prosecution ready to proceed?
Your Honor, before we proceed, we have some housekeeping matters we'd like to
Okay,
address.
housekeeping.
Your Honor, we have Exhibit A and Exhibit B posted on the back wall.
Thank you.
We ask that these two exhibits be marked as Exhibit A, Prosecution Exhibit A and Prosecution Exhibit B. They have already been shown to counsel.
So stipulated?
Yes, Your Honor.
All right, the exhibits are admitted into evidence.
Oh, Your Honor, excuse me, the defense would request that before Exhibit A and Exhibit B be entered into evidence that sufficient foundation be laid for them in
I'm
the
sorry,
trial.
I thought that's what you were stipulating to.
Oh, no, Your Honor, excuse me.
All right. Okay, go ahead.
We just to clarify, we just asked for them to be marked as Exhibit A. We will.
You did. I jumped ahead.
No problem, Your Honor. And next, Your Honor, we ask that the stipulations be constructively read into the record.
Yes.
Yes, Your Honor, under Rule 3.1D, they have already been entered into evidence.
Good.
And we ask the court to pay special attention to stipulations 13 and 15 that qualify Dr. Berg, Dr. Sanchez, and Officer Doherty as experts in their respective fields.
Yes, thank you.
Yes.
All right.
Lastly, Your Honor, the prosecution asked free movement about the courtroom.
Yes,
The defense requests the same, Your Honor.
yes, that's fine.
Thank you, Your Honor.
Your Honor, the defense has also brought with them an extra copy of the case and rule book in case Your Honor is not provided with that.
Actually, I have three of them.
Great, Your Honor.
Thank you.
Thank you, Your Honor. Nothing further from the defense.
All right. The prosecution calls first witness, please.
Your Honor, the prosecution would like to deliver their opening statement at this time.
Well, that would be a good idea.
Thank you, Your Honor. May I proceed?
Yes, go ahead.
Your Honor, this is a case about the reckless disregard for the life of a classmate. Defendant Ray Concha was a senior at Rosewood High, engaged in the illicit sale of dangerous drugs to students at her school. The defendant was greedy and was only looking to make a quick buck off selling drugs. But the defendant was dealing with Adderall, a prescription form of amphetamine that can cause death. She went too far. She gave Adderall to her friend Jason, and Jason died from it. Your Honor, under California statutes, this intentional act constitutes for second-degree murder. Accordingly, the people charged the defendant with 2 counts. 1, possession with the intent to sell a controlled substance, and 2, second-degree murder. For some time before the start of the defendant's senior year, Rosewood High has been experiencing a serious drug problem. Because of this, school authorities brought in Robin Doherty, an undercover police officer, to pose as a student under the name of Sam Shumway. Only the principal, Mr. Riley McAllister, knew of the officer's true identity. While at Rosewood, the officer acquainted himself with the defendant, Ray Concha, the victim, Jason Johnson, and another senior year student, Alex Weaver. Tonight, the people will prove that the officer obtained sufficient evidence that proves the intentional acts by the defendant. Not only did the officer search the defendant's car and find drugs for sale, but also heard from the defendant herself that she, quote, has a hookah for Adderall. On March 27, 2013, the victim, Jason Johnson, collapsed at Rosewood High's morning band practice and died on the way to the hospital. Dr. Ricky Sanchez, the chief medical examiner and county coroner for Rosewood County, examined Jason's body and determined that Adderall was the cause of his death. Your Honor, tonight the people will prove that the defendant, Ray Concha, is guilty of both charges. First, for possession with the intent to sell a controlled substance, the people will prove that 1, the defendant possessed Adderall in a usable amount, and 2, the defendant possessed Adderall with the intent to sell it. Next, for second-degree murder with malice aforethought, which includes implied malice, the people will prove that 1, the defendant gave Adderall to Jason, 2, the defendant gave Adderall to Jason and knew it was dangerous to his life, and 3, the defendant acted with conscious disregard for the life of Jason. Your Honor, we ask that at the conclusion of this trial, you find the defendant, Ray Concha, guilty of both these charges. Thank you.
Your name, please.
Gabe Horn. Thank you.
The defense chooses to make its opening statement.
Yes, Your Honor.
Go ahead.
And once again, for scoring purposes, my name is Sadie Brooke.
Thank you.
May I proceed?
Yes.
More than one. Tonight you will learn there was more than one reasonable explanation for the death of Jason Johnson on March 27, 2013. Jason's death at age 17 was a tragedy. There's no disputing that. And there's no disputing that Jason died just days before his scheduled surgery to correct his heart condition. But, Your Honor, tonight you will also learn that Jason consumed alcohol. Dr. Burke, the medical expert you will hear from tonight, will tell you that there was no way to confirm whether the alcohol, or Jason's pre-existing heart condition is what killed him. And tonight you will learn that several students took Adderall illegally. Jason Johnson, deceased, was one of these students. Alex Weaver, a friend of Jason's, is another. And Alex Weaver will tell you himself that he took Adderall without a prescription, that he took Adderall with Jason the night before he died, and that he never actually saw Ray give or sell Adderall to Jason. Your Honor, tonight, Alex Weaver is the only student out of 4,000 students that will tell you that Ray was a drug dealer. Alex Weaver only turned in Ray after 6 other drug incidents had already occurred. Drug incidents that you will learn all happened after Alex transferred to Rosewood. Tonight, the principal of Rosewood High and the undercover officer he hired to find the drug dealer will testify. After more than 7 weeks of this investigation, no real progress was made. No evidence obtained, no witnesses found, no drug transfers observed. The first and only time the officer received any information he acted upon was when Alex Weaver came forward and pointed the finger at Ray. The state has to prove beyond a reasonable doubt that my client, Ray Concha, sold Adderall to Jason, and that Adderall is what killed him. But, Your Honor, tonight you will learn that there is more than one cause of Jason's death. Tonight you will learn that there is more than one person who could have framed Ray. Tonight you will learn that there is more than one possible cause of Jason's death. More than one. For these reasons, at the end of this trial, my co-counsel, Ms. Walter, will ask you for a verdict of not guilty. Thank you. Excuse the interruption.
Do you have a rebuttal?
No, Your Honor, we're not allowed to have a rebuttal. It's
That's what I would have expected in real life. The prosecution, please call us first witness.
Yes, Your Honor. The prosecution would like to call Officer Doherty to the stand.
Officer Doherty, please proceed to the witness stand. Please raise your right hand. Do you solemnly affirm that the testimony you are about to give will faithfully and truthfully conform to the facts and rules of the mock trial composition?
I do.
Thank you. Please be seated and state your name for the court, spelling your last name.
My name is Dan Wheelan, W-H-E-L-A-N, and tonight I'm Officer Robin Doherty.
For scoring purposes, my name is Bhavik Patel, P-A-T-E-L. May I proceed, Your Honor? Good evening, officer. What is your profession?
Good evening. I'm a police officer for Rosewood County. I'm an expert in drug recognition and sales and have extensive training in those areas.
Officer, what happened on March 27th, 2013?
Jason Johnson, a student at Rosewood High School, died after taking Adderall, a prescription form of amphetamine.
Did you know Jason Johnson?
Yes, sir. I was in the high school marching band with him.
Can you explain your role at Rosewood High School?
I was assigned as an undercover police officer, posing as a senior year transfer student to figure out who the drug dealer on campus was.
Who knew your real identity?
Only Principal McAllister. Everyone else knew me as Sam Shumway.
When you began your investigation, did you have any leads?
Yes, sir, I did. I was informed the drug dealer may be someone in the marching band.
How did you use this lead?
I thought it was a good lead, so I joined the marching band and befriended 3 students. Alex Weaver, Jason Johnson, and the defendant, Ray Concha, who was sitting at the end of the defense table wearing a blue and white sweater.
Your Honor, may the record reflect that Officer Doherty correctly identified the defendant? Did you have any suspicious incidents with your new friends?
Yes, sir. About 2 weeks after I started my investigation, Jason Johnson failed to show up for band practice. I asked what happened, and the defendant said Jason couldn't keep up with the addy.
What happened next?
Then the defendant said, addy means Adderall, Shumway, smart pills. Apparently, Jason had a bad reaction to the drugs. Then the defendant offered me Adderall, saying, "You interested in that stuff? I have a hookup."
The defendant said, "Are you interested in this stuff?" Then offered you Adderall?
Objection, Your Honor, leading and asked and answered.
Ooh, go ahead.
Yes, sir. She did.
Thank you. Now, did you have any experiences with your new friends off of campus?
Yes, it was strange. I saw the defendant buying groceries in a different town from where she lived.
What was the defendant buying?
I saw 5 boxes of small and large plastic Ziploc baggies in her shopping cart.
And was this unusual?
Yes, sir, it was.
Thank you. Now, can you take me to the day of March 27, 2013? What happened that morning?
Jason Johnson passed out during band practice and later died on the way to the hospital. They found Adderall in his system.
What did you do after hearing this?
After that, I went to talk to Jason's friend, Alex Weaver. I then told Alex we should figure out who did this to Jason. I was later called into the principal's office.
Who was inside the principal's office?
Principal McAllister and Alex Weaver.
Before we discuss the conversation with the principal, did you ever search the defendant's car?
Yes, sir, I did.
And before we get to what was inside her car, can you tell me why you searched the defendant's car?
Yes, sir, I can. In the principal's office, Alex Weaver told me the defendant was a drug dealer who kept drugs in her car. Alex also told me he had previously seen the defendant sell drugs, as well as Alex saw the defendant hand Jason Johnson some pills earlier that morning.
Thank you, officer. Can you turn your attention to Exhibit A and Exhibit B? What are these exhibits?
These are the pictures I took of the items in the defendant's car on March 27th.
Is this an accurate portrayal of what you saw that morning?
Yes, sir, it is.
Can you please describe the backpack seen in Exhibit A?
It's a blue backpack with black and gray cords. That backpack, the defendant almost always had that backpack with her at school.
Now, what is in Exhibit B?
Exhibit B is a picture of the Adderall pills in plastic baggies. Also, the 2 generic pill bottles found in the defendant's backpack, totaling 83 Adderall pills, as well as a roll of money, totaling $180 with a $20 bill on that outside.
Your Honor, at this point, can Exhibit A and Exhibit B be moved into evidence?
Any objections?
Yes, Your Honor. As this officer has not explained to the court as to how he determined that the Adderall in the plastic bags is definitely Adderall, we ask that they lay foundation before the exhibits are entered because it specifically says photo of Adderall pills under Exhibit B.
Okay. Go ahead, please.
Officer, how did you identify that those pills were in fact Adderall?
Tests later confirmed that these were Adderall pills.
And where were these tests taken?
at our police headquarters.
Thank you, Your Honor. Now may Exhibit A and Exhibit B moved into evidence?
Yes. Further objection?
No objections, Your Honor.
Exhibit A and B, 1 and 2 are admitted into evidence.
Thank you, Your Honor. Now, is it unusual to find Adderall in plastic baggies?
No, not for high school drug dealers. This was not for personal use. High school drug dealers often use plastic baggies to sell narcotics.
What did you do what happened after the investigation was completed?
The principal got the defendant out of class and brought her to the car. I then read her Miranda rights and told her I was an undercover police officer.
Did you ask her whose backpack that was?
Yes, sir, I did. She naturally denied it, shrugging her shoulders.
What did you think about that?
Despite the defendant's self-serving denial, I had probable cause to arrest her for the murder of Jason Johnson and the possession of Adderall with intent to sell.
Thank you, Your Honor. No further questions?
Cross-examination?
Yes, Your Honor.
Name, please.
Christina Wadsworth. Good evening, officer.
Good evening.
Now, I'd like to begin with a few things that you testified to on direct examination, and I wrote them down to make sure that I have them correctly. You said, and I quote, "It was strange that I saw the defendant buying groceries in a town other than where she lived," correct?
Yes, ma'am, that is correct.
But you never spoke to the defendant, did you?
No, I did not speak to the defendant in the store.
So you have no idea as to why she was buying plastic bags in a different town, do you?
I did not. I just thought it was strange she would be buying groceries in a different town.
So, officer, because you didn't know, you assumed it was strange, yes or no?
That is correct.
You made assumptions in your investigation?
Objection, Your Honor. Argumentative.
Grant.
I can move on. Now, I'd like to talk about something else. You said that you always saw that Ray Concha was always carrying a blue backpack at school, correct?
Yes, Ray almost always had that backpack at school.
Okay, well, officer, almost always is different than always, correct?
Yes, that is correct.
And on direct examination, you testified to always, yes or no?
I may have slightly misspoken. I meant almost always.
So, officer, it's your testimony that you spoke during direct examination?
Objection, Your Honor. Relevance.
Rule.
Officer, yes or no, you misspoke during direct examination?
I made a slight mistake. Yes, that's correct.
Okay, now, let's go back to the middle of February when Jason didn't show up at school. It was Alex Weaver that first told you Jason had a bad reaction to drugs, correct?
That is correct. But then, yes, it is correct.
And after Ray Concha said, "I have a hookup," you laughed, didn't you?
I did not laugh.
Officer, did you give a witness statement in this case?
Yes, ma'am, I did.
And did you include all relevant information in that witness statement?
Yes, that is correct.
Were you truthful and accurate in that witness statement of the murder investigation that you were the lead investigator in?
Yes, I did.
Are you aware that on page 23 you said, "Ray laughed and said, 'I have a hookup. I pretended to laugh.'" Is that what you said in your witness statement?
Yes, ma'am, I did.
So just now you testified that you didn't laugh, correct?
Yes, ma'am, I did. That is correct. And I
Once
made a
again,
mistake.
officer, did you make a mistake on the stand tonight?
Yes, a human error, yes.
All right. Now let's talk about the morning of Jason's death. After you spoke with Alex Weaver, she came forward 2 hours later to the principal, right?
He did, yes.
Sorry. And you can't testify to Alex Weaver's whereabouts during that 2-hour period, can you?
No, I cannot.
And it was Alex Weaver's statements that led you to search the defendant's car, correct?
Yes, ma'am, that's correct.
Okay. And when you got to the defendant's car, it was unlocked, yes or no?
Yes, it was unlocked.
And Alex Weaver is the only one student out of 4,000 at Rosewood that you can testify to tonight who came forward and alleged my client dealt Adderall. Yes or no, officer?
Alex Beaver was the only one, correct.
Thank you, officer. Your Honor, I have no further questions.
Rebuttal?
Redirect, Your Honor. Yes. May I proceed?
Yes, go ahead.
Officer, whose backpack where did you see that backpack seen in Exhibit A?
That backpack the defendant almost always had with her at school.
Objection, Your Honor, creation of material fact. All that this witness's statement says is that Ray Concha carries around a green backpack and that that backpack is blue. This witness's statement does not make a correlation between the two backpacks.
Your Honor, I simply asked where has he seen that backpack, and the officer directly says that he's seen that backpack on the back of Ray Concha almost always during school. Thank you, Your Honor. And officer, did you have reasonable cause to arrest the defendant?
Yes, sir, I did.
Thank you, Your Honor. No further questions. May this witness please be excused? Thank you.
Call your next witness, please.
Yes, Your Honor. The prosecution would like to call Mr. Alex Weaver to the stand.
Alex Weaver, please proceed to the witness stand.
Sir, your name.
Yes. For scoring purposes, my name is Justin Baptista.
Please raise your right hand.